Lewis the Wall.
Tēnā koe te mangai o te whare i ngā mana i ngā reo rau rangatirama, tēnā koutou, tēnā tātou katoa. Ngā uri o te Atiawa, tēnā koutou, ngā hapu, Ngāti Rahiri, o tā raua, manu korahi, poke tapu, poke rangiora, Ngāti te whirikura, Ngāti tapu ri kino, Ngāti te whiti. Nō reira, tēnā tātou katoa. Today's a really special day, and it's a special day because this is Te Atiawa's Day. It is the day where we as parliamentarians support them in their process of resolving historical Treaty of Waitangi issues, where we as parliamentarians tautoko the process. So it's a bit of a sad day when we're not 100% focused on the whānau who have travelled so far today because of a Taranaki claim that went to the Waitangi Tribunal initiated by the Taranaki Māori Trust Board in 1987. So we're here because of the mahi that the tūpuna of Te Atiawa undertook when we opened up the opportunity to investigate Treaty of Waitangi breaches right back to 1840. And what happened after the Taranaki Māori Trust Board in 1987 took the first case was that the Waitangi Tribunal released a report on the 11th of June 1996. And that report was called the Taranaki Report, Kaupapa Tahi. It took another 14 years for the process to be started again. And so in 2010, the Crown recommended negotiations with Te Atiawa. The second reading of a bill is about the principles of the bill, and it's also to provide some kōrero from the submissions. And so for us to do that, I just want to focus on what this process is all about. This is about the Treaty of Waitangi Act of 1975, and in the purpose of that act it says they wanted to create a tribunal to make, and I quote, recommendations on claims relating to the practical application of the treaty and to determine whether certain matters are consistent with the principles of the Treaty of Waitangi. The Amendment Act of 1985 then enabled us to go back to 1840. So the bill before the House today, the Te Atiawa Claim Settlement Bill, gives effect to the deed of settlement agreed by the Crown and Te Atiawa, which was signed on the 9th of August 2014. I'd like to read from the submission of Liana Potu, and I quote, "The settlement of these claims has taken generations to reach this point, and we are grateful to our many tūpuna who worked tirelessly on this kaupapa so that their mokopuna would not have to carry the burden that they carried for so long. I am well aware that the settlement does not even come close to compensating our people for the losses and sacrifices we have endured, but we are still here and intend on being around to see that the work of those before us is not wasted." So on behalf of Te Kotahitanga o Te Atiawa, they support the bill in its entirety. So I think it's really important that we focus on what's in the bill, and I want to take the opportunity to read some sections from the Taranaki Report. 3.6, Waitara. The context is really interesting because obviously when Thomas Brown, who became our Governor-General, replaced Grey in 1855, he was sent here for a very specific purpose, and that was to secure lands. And it says in that report that his resolve to secure the Taranaki lands for settlement was an imperative of his appointment. And so in 1986, he appointed a board to inquire and to report on the status of Taranaki lands. And I just want to quote from that board, from that report, about the board's view. And it was, and I quote, the tribe, Taranaki, had the only authority to dispose of land, and while the individual had certain possessory rights, there is no such thing as an individual claim clear and independent of the tribal right. So it was really clear that any lands that were to be sold had to be agreed by the tribe, that individuals couldn't sell land. Governor Brown then visited Taranaki on the 8th of March 1859, and he announced a policy, and I'd like to read that policy to the House today. The first was that any person committing violence or outrage within European boundaries would be dealt with under the criminal law. But secondly, he said he would not buy land with a disputed title and would buy no man's land without his consent. And herein, I guess, lies the issues around peka peka. And I found it interesting when I went on to New Zealand in history, because there is a section called the New Zealand Wars and a Taranaki War timeline. And it starts in 1859, where it says, Atiawa tribe offers to sell land at Waitara. Surveying commences in 1860, but is interrupted by Wiremu Kingi Te Rangitake, a Te Atiawa chief, who objects to this land sale. So I found it really interesting that it said that the tribe offered to sell it, but actually the rangatira objected to the sale, because obviously the issue wasn't about the tribe selling it. It was about land agents at that time finding someone, an individual, who was willing to sell the land. And I want to quote again from the tribunal report, and the person that wanted to sell it, his name is Te Teira. And Kingi was aware that he had asked for payment, that he'd entered into this negotiation with Governor Brown, and this is what he wrote to the Governor. I quote, I will not agree to our bedroom being sold, I mean Waitara here, for this bed belongs to all of us, and do not you be in haste to give the money. If you give the money secretly, you will get no land for it. You may insist, but I will never agree to it. All I have to say to you, O Governor, is that none of this land will be given to you. Never, never, till I die. I have heard it said that I am to be imprisoned because of this land. I am very sad because of this word. Why is it? You should remember that the Māoris and Pākehās are living quietly upon their pieces of land, and therefore do not you disturb them. In preparing, I guess, for my kōrero today, I found a press release dated the 10th of October 2000. It was by the Honourable Parekura Horomia, and it was to mark the 25th anniversary of the Waitangi Tribunal. And he quotes from Judge Jury of the time, who after 20 years of experience had 4 things to say. The first was the room for ethnic misunderstanding. Therefore, in its reporting, the Tribunal has tried to explain Māori cultural views as it appeared from the evidence so that Māori and Pākehā might understand one another better in the future. The second was the need to report fully in order to put the past to rest. 3, the need to make practical recommendations so that something positive might happen in the future. And 4, and that the process underlined for him how important it is that all people should have access to an appropriate judicial forum to express legitimate concerns. So I think what the process has endeavoured to do is to provide that forum. But for some people who aren't aware of what's happening around them, they don't engage early enough. And I think if we look at what's going to happen in terms of the debate around Waitara and the proposition that the New Plymouth District Council have put to the House, I think it's really important that we focus on the right of first refusal for the whānau of Te Atiawa and Waitara. And I just want to highlight Article 2 of the Treaty of Waitangi, actually, where the Queen confirmed and guaranteed to Māori the full, exclusive and undisturbed possession of our lands for as long as we wish and desire to retain them in our possession. And what we agreed in being guaranteed our full and undisturbed possession was that the Crown had an exclusive right of preemption over that land. And I guess if we want to look at Waitara and an opportunity for Te Atiawa to have the first right of refusal, actually we should look no further than the treaty in enabling that specific provision in the Waitara Bill. Because from the council position, they're saying we're going to give Te Atiawa a monopoly. They'll have an exclusive right and only right to buy the land. Well, I guess my challenge to us is what's wrong with that? Because that's what we said in the treaty. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa.